On the surface, Blake Lively's lawsuit looks like a Hollywood star finally standing tall against powerful forces, a perfect case where she seems to be gaining ground at every turn. But peel back the curtain, and you'll see that the so-called victories she's celebrating may not be as solid as they appear. Her biggest problem isn't even the defendants she originally aimed at. It's Jed Wallace, a PR consultant who was never her employer, never part of her film, and yet is methodically dismantling her case with cold, precise arguments. While fans cheer her small wins in discovery, Wallace's legal scalpel is slicing her claims to pieces, and what he's exposing could collapse not just her accusations against him, but the entire foundation of her case. At first glance, Blake Lively seems unstoppable. Each time she files a motion in discovery, the judge grants it, making it look like she's winning at every turn. But here's what most people don't realize. Judges often lean in favor of plaintiffs in sensitive disputes like harassment or discrimination because they don't want to appear biased or shut down a potential victim's chance to prove their case. That doesn't mean the plaintiff is actually winning where it counts. Discovery is about collecting evidence. It doesn't prove that evidence exists or that it can hold up in court. So, while the headlines might suggest Blake is pulling ahead, the reality is her case has to survive much tougher tests like motions to dismiss, summary judgment, and potentially a jury trial. And that's where cracks are already showing. The real twist comes with Jed Wallace, a man who isn't a Hollywood power broker, isn't her employer, and wasn't directly tied to her project, yet has emerged as her biggest obstacle. Wallace, a PR consultant, has responded to her lawsuit not with theatrics or emotional arguments, but with cold, clinical precision. His lawyers go line by line, allegation by allegation, dismantling her claims in a way that feels less like a courtroom drama and more like a surgical operation. One of their filings mocked her response as a 2-paragraph attempt in a 31-page brief, dismissing it as hardly a response at all. The tone is relentless, calculated, and it sends a clear message. Wallace isn't just defending himself, he's systematically tearing down her case piece by piece. Blake's core claim is that Wallace, along with others, launched a retaliation campaign designed to smear her reputation, portraying her as rude, tone-deaf, and dismissive of serious issues like domestic violence. She argues this wasn't mere criticism, but a deliberate plot to discredit her before she could go public with harassment accusations. The problem is, retaliation laws aren't built on speculation or image damage. They're built on actual adverse employment actions. And as Wallace's team points out, what she's really describing is reputational harm, which legally falls under defamation. Defamation is far harder to prove, especially for a public figure like Blake, because the bar requires identifying specific false statements and proving actual malice. By tying her entire injury to damage to her reputation, Blake may have unwittingly reframed her own case into something she can't possibly win. This is where the legal walls start closing in. Under New York law, if a claim boils down to reputational harm, it belongs in defamation, no matter how you try to repackage it. And defamation claims come with brutal restrictions. A shorter statute of limitations, strict requirements to identify exactly what was said and by whom, and for public figures like Blake, the nearly impossible hurdle of proving actual malice. Wallace's attorneys are hammering this point relentlessly, arguing that no matter how she frames it, as retaliation, false light, or conspiracy, her claims sound in defamation. Worse, she hasn't been able to point to a single defamatory statement made by Wallace. Her attempt to sidestep the defamation exception isn't just weak, it's almost non-existent. And in court, silence on a critical issue speaks volumes. As if that wasn't bad enough, Blake has another fatal flaw in her strategy. She's leaning heavily on California's Fair Employment and Housing Act, or FEHA, to support her claims. But FEHA has one very clear rule. It doesn't apply outside of California. If you're not a California resident, weren't working in California, and the conduct didn't occur in California, FEHA simply doesn't apply. Period. And Blake herself admitted the incidents she's complaining about happened in New Jersey and New York. That admission is devastating, because it doesn't just weaken her case against Wallace, it threatens the entire case against all defendants. Wallace's lawyers pounced on this, pointing out that by her own testimony, the California law she's trying to rely on is irrelevant, leaving her claims with no legal backbone. Why, then, is she trying to drag California law into a New York courtroom? The answer lies in a controversial tactic known as forum shopping, choosing a court not because it's the right venue, but because it gives you procedural advantages. Blake filed in New York because subpoenas there can be issued without notifying the other side, a loophole she used to obtain evidence that she likely couldn't have gotten in California. But that choice is now haunting her. Wallace's team highlights this as evidence that she's twisting the system to fit her case, rather than letting the facts stand on their own. And in court, when a judge senses forum shopping, it often undermines credibility, making her look less like a victim seeking justice and more like a strategist trying to manipulate the legal map. Even setting aside the jurisdictional mess, her retaliation theory itself falls apart under scrutiny. Blake claims Wallace and others retaliated against her by spreading damaging stories, not because she had already spoken publicly, but to silence her in case she ever did. The problem? Retaliation requires a protected activity, something you've actually done, not something you might do. Retaliation laws don't cover hypothetical future actions. Wallace's lawyers make this clear. Her argument is built on speculation, not fact. And when pressed under oath, Blake admitted she couldn't name a single article or statement Wallace published that harmed her. That kind of admission doesn't just weaken her retaliation theory, it guts it entirely. What makes this even stranger is the way Blake's own actions contradict her claims. Most people who experience harassment try to distance themselves from the source, but Blake did the opposite. After the alleged harassment, she pushed for more involvement in the project, more creative control, and closer proximity to the very people she accused. Wallace's lawyers highlight this contradiction to suggest that her motivations might not align with her accusations. Was she truly harassed, or was she leveraging allegations as bargaining chips to gain control over the film? That's the uncomfortable question lurking behind her case, and it's one that a jury would have to consider if this ever makes it to trial. What makes Wallace's defense so effective is not just what they argue, but how they argue it. While Blake's filings stretch over 31 pages, Wallace's replies cut straight to the point with far fewer words, each one landing like a scalpel slicing through her case. They don't just argue jurisdiction, they argue the merits. They don't just poke holes, they map out multiple avenues for dismissal: the defamation exception, lack of jurisdiction, speculative retaliation, and even the absence of a protected activity. It's a multi-pronged attack that doesn't rely on volume but on precision, and the strategy is so sharp it doesn't just defend Wallace. It gives the other defendants, like Wayfair, a ready-made blueprint for dismantling her claims as well. The most devastating blow, however, comes from Blake's own testimony. For someone claiming a coordinated smear campaign destroyed her reputation, she couldn't identify a single harmful statement Wallace made. Not one. Her daily media blitz accusation collapsed the moment she was asked for specifics. In court, failing to provide evidence for the central claim is catastrophic. It makes the case look less like a fight for justice and more like reputational gamesmanship, where the lawsuit itself becomes the weapon. Wallace's lawyers don't need to scream this from the rooftops. They simply point to her silence, and that silence says everything. And this isn't just about Wallace. If his motion to dismiss succeeds, it sets a precedent for the other defendants. Wayfair, the company at the center of her accusations, can take the same arguments: defamation exception, lack of jurisdiction, speculative retaliation, and apply them to their own defense. In other words, Wallace isn't just defending himself, he's paving the way for everyone else to walk free. If that happens, Blake won't just lose this case. She'll risk damaging her own credibility as both a plaintiff and a public figure. The ripple effect could extend far beyond the courtroom, into her career and public image. So where does this all lead? The judge hasn't ruled yet, but Wallace's team has given the court multiple clear, legal reasons to dismiss the case. Even if Blake continues to celebrate minor victories in discovery, those wins are meaningless if the core of her case collapses under its own weight. Her reliance on California law in a New York courtroom, her inability to identify specific defamatory statements, and her reliance on speculative retaliation all point to one conclusion. The foundation of her case is crumbling. And the more Wallace's team presses their arguments, the more it looks like this isn't just about a failed lawsuit. It's about a reputational gamble that could end up backfiring in the biggest way. Blake Lively may have Bell,